Yeah, he is. I see it. There you go.
I apologize for that.
No problem.
I would, may it please the court, I would like to go through a brief synopsis of the history of this case. Lawrence was cited by the County Code Enforcement Board. Uh, the company sought a hearing before a special magistrate, and the citation was upheld. The special magistrate gave Lawrence 60 days to comply with his order. Lawrence filed a deck action in the circuit court that was later converted into an appeal. In the meantime, the county filed an affidavit of noncompliance with the special magistrate's order, and fines started running. Lawrence contested the claim of noncompliance, and the special magistrate held a series of hearings. In February 19, the magistrate froze the accrual of further fines pending resolution of the dispute as to whether Lawrence was in compliance. The special magistrate repeated that freeze on several more occasions, culminating in July 2019, when he denied Lawrence's contest and issued a final order. In that final order, the special magistrate continued his freeze on the fines, quote, until the resolution of the appeal case 18-CA-10128. That was the original deck action that Lawrence had filed in circuit court, and that was subsequently converted into an appeal. Lawrence also appealed the final order denying his contest. The two appeals were consolidated. While the appeals were pending, Hillsborough County sought to alter the special magistrate's final order. And they sought to do that by simply asking him to delete the freeze that he had placed on the fines. In September 2019, the special magistrate noticed a hearing for a staff report. There was no staff report. It was to consider the county's request to unfreeze the fines. Of course, the special magistrate had no jurisdiction over the lower tribunal case at that point because the appeals had been filed. Lawrence went to the circuit court and sought a writ of prohibition. Judge Stoddard issued a show cause order to the county, but subsequently denied the writ of prohibition. Lawrence sought reconsideration of that order. Meantime, the county went back and tried again with the special magistrate. On November 12th, the special magistrate sent another notice of hearing, scheduling a hearing on November 15th, 3 days later, for a staff report. Lawrence filed an emergency motion for injunctive relief with Judge Stoddard. The special magistrate held the hearing on the morning of November 15th and indicated that he was going to unfreeze his fines. Judge Stoddard held an emergency hearing that afternoon, at which both parties were present, had the opportunity to call witnesses, made argument, and Judge Stoddard enjoined the county and the special magistrate from proceeding further in the lower tribunal. Now, in late 2020, after the circuit court issued its appellate opinion denying Lawrence's appeal, Lawrence sought certiorari relief in this court. The county then moved to dissolve Judge Stoddard's injunction. He granted the motion to dissolve the injunction almost immediately. Less than 24 hours had passed before he dissolved the injunction. He did that without notice, without giving Lawrence the opportunity to respond, without giving Lawrence the opportunity to attend a hearing, call witnesses, present argument, anything. Now, due process of law, as we all know, is guaranteed by the U.S. and Florida constitutions.
Before we go into the procedural argument,
Yes.
In light of the fact that this court has denied the petition for cert to review the circuit court's appellate decision, are the
Yes.
issues before this panel now moot?
I don't believe so. I don't believe that a denial of due process in this context is ever moot.
Well, this was a stay, and if there's nothing left to go because the cert was denied, the appeal was contrary to your client's position, it would assume that the fees that the county was levying would go. The only question would remain, what is the proper amount? I mean, what relief would this court grant you?
Well, the question, as I see it, Your Honor, is are there arguments, are there facts that would justify continuing the stay in effect? We don't know the answer to that because, frankly, we haven't researched it. I do think that the proper amount becomes a significant issue. After Judge Stoddard dissolved his injunction, the county immediately held a hearing for...
Here's my question. If there's an issue as to the amount,
yes,
wouldn't that be before the court that has jurisdiction to ascertain that amount? And that would be the trial court, because witnesses would have to be called, a record would have to be established, a timeline found, that type of thing. It's not something that we would customarily do at this court. Is that correct?
We understand that, Your Honor. This fact is particularly, I think, relevant to your consideration here. At that hearing before the special magistrate, he reimposed the fines retroactively to the date that Judge Stoddard held his first emergency hearing, 15/2019, instead of the date that the appeal was completed. And by the way, mandate didn't even issue from the appellate court until December of 2020. And yet in October of 2020, the special magistrate assumed jurisdiction and issued this order retroactively imposing fines for a year. And so we believe that there are reasons to go back to Judge Stoddard and reimpose the injunction and let the county once again argue for lifting the injunction.
This wasn't exactly an injunction, was it? This was a stay, which seems to be a different type of, legal beast that we often see.
Actually, Your Honor, we disagree with that.
Okay.
Regardless of how it's denominated, if an order grants injunctive relief, directs somebody to do something that they didn't want to do, or directs them not to do something that they want to do, then it's an injunction. And a temporary injunction is something to preserve status quo.
Doesn't that create a whole nother problem? Because if it's an injunction and it was given by the special magistrate, sua sponte, that would certainly impact some notions of due process, whereas if it's a stay, you might argue the inherent power of the trial court to stay its proceeding to allow a higher court to review it.
The higher
That's
court.
part of my concern as I work. So I'm looking forward to everyone's responses to guide me in this.
Sure. It was the higher court that issued the injunction, Your Honor. Judge Stoddard was a circuit court judge. The proceedings came out.
And that's the one he dissolved. Your argument is without due process.
Yes. Yes. And he was enjoining the lower tribunal, i.e. the code enforcement special magistrate, from acting further in violation of the circuit court's appellate jurisdiction.
And his injunction was entered so long as the case proceeded, and did he terminate the injunction when the circuit court, acting in its appellate capacity, issued its ruling?
He did not. He terminated his injunction after the county requested that, which was after the circuit court issued its ruling, but while we were seeking cert in this court.
Okay, thank you.
Yes. And so regardless of how it's denominated, a temporary injunction to preserve the status quo in order to prevent harm from occurring before a dispute is resolved is an injunction, and that's true whether it's called an injunction or a stay or an abatement. And the City of Sunny Isles Beach versus Temple B'nai Zion, Inc., 43 Southern 3rd 904, that came out of the 3rd DCA in 2010, holds that, as does Corey v. Helmsley, 602 Southern 2nd 617, and that's a 3rd DCA case from 1992, as does Cone v. Anderson, 944 Southern 2nd 1073. That's a 1st DCA case from 2006. There are others. Unfortunately, I couldn't find one from the 2nd DCA that discusses the issue, but the other DCAs that have considered it unanimously say if the language is injunctive or the purpose is to prevent harm from occurring before a dispute is resolved, then it's an injunction, not a stay. Okay. We argue, of course, that Judge Stoddard's dissolution of the injunction without due process should be reversed. Every time that this court has confronted the issue of the propriety of an injunction being entered or modified or dissolved without proper notice and without the opportunity for a full and fair hearing, this court has reversed the action of the lower courts. We simply ask this court to continue that practice. Lawrence's due process rights were clearly violated when Judge Stoddard dissolved the previously imposed injunction without giving Lawrence even the opportunity to respond to the motion to dissolve, the opportunity to request a hearing, or a hearing at which he could present witnesses and argument. This court has said in this connection, quote, "It is fundamental that the constitutional guarantee of due process, which extends into every proceeding, requires the opportunity to be heard, to be full and fair, and not merely colorable or elusive." And that's a case called Smith v. Smith, 964 Southern 2nd, 217, a 2nd DCA case from 2007, and it's an injunction case. In that case, the lower court held an injunction hearing. It refused to permit Mr. Smith to testify and refused to allow him to present witnesses. It then entered an injunction against him, and this court reversed. Hillsborough County didn't really contest the due process violations in its brief. It simply asserted that a response to its dissolution motion was unnecessary. A motion for hearing wasn't needed. A hearing wasn't needed. They offered no record support for those assertions. They offered no case law supporting its conclusions. The county now asks this court to affirm the stripping of Lawrence's constitutional rights because that's the convenient thing for the county. And there's no authority for it whatsoever, not anywhere that we could find in this state's jurisprudence. And it isn't for the county to decide whether hearings are necessary, whether a response is necessary. Those are things that are guaranteed constitutionally to Lawrence. It also isn't for the county to decide whether there was a need for the injunction to continue. That was Judge Stoddard's province. He could only make that decision after giving both sides fair notice and fair opportunity to be heard, to present witnesses and arguments, just as he did when he granted the injunction motion. Thank you.
Thank you, Ken.
Okay, Mr. Hodges, you didn't mention whether you wanted to reserve rebuttal time, but you have about 5 minutes left, so you can use them for rebuttal.
Thank you, Your Honor.
Okay, Mr. Pope, you're up.
Sorry about that. Good morning. My name is Ken Pope. I'm an assistant Hillsborough County attorney, and I represent the county. With all due respect to Mr. Hodges, the county views this case as basically a 3-year effort to avoid the running of the fines. First, they launched a substantive offensive, and when that failed, then they attacked the case procedurally. On September 17th, 2018, the Code Enforcement Board, we refer to it as a CESM in our brief, issued an order imposing fine. It gave Lawrence 30 days to comply the violations. And when that didn't happen, the fines would begin to run. The procedure allows for a contest hearing whereby you can argue that the Code Enforcement Board issued the order imposing fine in error. During that process, the Code Enforcement Board issued a stay. It said, and I quote, that the fines are frozen as of 2/8/2019 and shall remain frozen until a decision has been rendered on appeal case 18 CA 10128. That decision ultimately was reached in July 20th, 2020 and amended on August 11th, 2020. At that point, with the case having been decided by the circuit court sitting in its appellate capacity, the reason for the stay or the freezing of the fines by the Code Enforcement Board had already been met. At one point, the county went to have the fines unfrozen, and Judge Stoddard at that time issued his stay. The stay was during the pendency of the appeal, but nothing further than that. Once all the conditions had been met, the county once again went back before the circuit court, Judge Stoddard, and asked him to lift the stay, citing as the principal reason that the appellate case had already been decided. 8 days later, it went before the Code Enforcement Board and asked it to unfreeze the fines. The reason that the fines are significant to the county is because they are our principal pressure mechanism to get property owners who've been found in violation to comply their property. Throughout this process, Lawrence has made no effort to comply his property whatsoever. And if the fines had been frozen, then we would have had no way to pressure him. I think that Mr. Hodges made reference to the fact that once the fines were unfrozen, they were in effect non-pertunct back to when they had stopped running back on February 8th of 2019.
Mr. Pope, let me ask you a question, if I might, to establish a timeline, make sure I understand this. When Judge Stoddard issued his order terminating the stay, as you put it, at that time, the circuit court appellate panel had ruled. Is that correct?
That's correct, Your Honor.
Had the circuit court's mandate issued?
It
My
had not, Your Honor.
understanding, the stay ends when the mandate issues. Is that your understanding?
Judge,
So, go ahead.
No, from case law, that is my understanding as well.
All right, so arguably then, Judge Stoddard's ruling, if it was before the mandate, may have been premature. Is that correct?
I will concede that. Your Honor. And I mean, not to say that it's a trivial matter, but
is it now moot in light of the fact that
I don't believe that it is, Your Honor,
has issued the mandate and we have denied the petition of cert? Is there anything left to be done?
Oh, I understand your question now. I agree with you. There's nothing left to be done. In fact, and I think it was March 10th of this year, the second DCA denied the writ that was filed in response to the circuit court's decision of amended August 11th, 2020. So for that reason, there's really nothing left to be done. To address some of the issues that Mr. Hodges raised, with regard to the fines running retroactively, or he refers to as not having the proper amount, the county's position is that the fine should have run in a month after September 17th, 2018. And the reason that it really doesn't affect his client is because had he won the appeal, then the fines would have gone away. But now that he has not prevailed, the county should be entitled to have the full effect of the fines, because again, that's our ability to pressure the property owner, his client, into complying. Now, I will say that the county isn't looking to, if you 200 times, whatever, how many days it's been since November of 2018 would be a lot of money. And it's not the county's effort to collect all of that money. He can certainly settle those fines once his client complies with the property, and that's really the only thing that we're seeking. He talks about also a due process issue, and I think that if you review the transcript, you'll see that when he went to the hearing in October of 2020, when the CESM began the unfreeze of fines, that he expressed no surprise at why he was at that hearing. He didn't object to the hearing. There's nothing in the record that would indicate that he wasn't prepared to go forward. So all of the arguments that he says that he could have made, he didn't attempt to make them at that time. So we think that that is actually a disingenuous argument as well. I really have no other comments to make other than the fact that the county would ask that the court affirm the circuit court's order granting the motion to lift stay, deny rehearing, and deny emergency motion. But I'm available for any question that the court may have for me.
Okay, thank you, Mr. Pope. Mr. Hodges for rebuttal.
Yes, Your Honor. Your Honor is right that the jurisdiction did not return to the special magistrate until December of 2020, when the circuit court issued its mandate. And so the October order reimposing the fines retroactively a year is probably void under existing case law regarding issuance of mandate. As far as and
wouldn't that be a matter of computation between your client and the county to determine how many days there were in there that arguably there was a procedural irregularity by Judge Stoddard because the mandate hadn't issued, and figure out what that time period is and compute whatever impact it has on the fines?
Well, Your Honor, I think you are right about that. However, the county—
Be careful, that doesn't often happen.
However, the county is not willing to do it simply because they imposed the fines a year retroactively from the day Judge Stoddard held his emergency.
Well, now that county has the benefit of this proceeding, and Mr. Pope, has been present for all this, and I think he understands and you understand kind of the points that we're looking at here.
Yes, Your Honor. Yes, Your Honor.
But you go ahead. I don't want to use up any more of your rebuttal time.
Well, no, I'm just thinking about your comment, Your Honor, and I disagree with Mr. Pope's statement that we didn't raise any issues at the October hearing where they reimposed the fines. We certainly raised the mandate issue. I believe we did raise the due process issue and complained about the notice not being given properly, in that it simply reflected it was for a staff report, once again, as opposed to a county's non-written motion, apparently, to reinstate fines retroactively a year. But that's neither here nor there at this point. The special magistrate acted, once again, in excess of his jurisdiction because mandate had not issued. And he did something frankly, I'm still amazed by it, that he imposed fines back to the day of Judge Stoddard's hearing. And it's a clear effort to get around Judge Stoddard's injunction, really is not giving Judge Stoddard's ruling due respect. He stayed the fines, or he stayed the proceedings in order to prevent the magistrate from interfering with the circuit court's jurisdiction. And yet the magistrate repeatedly tried to do that, which was the reason for the stay. And the magistrate's own order said that the fines would be stayed until the appeal was completed. And he did that voluntarily, by the way. The first time he imposed that freeze, no one asked him to. No one ever objected to it. No one ever appealed that. I mean, there were plenty of alternatives available to the county and the magistrate if they wanted the fines to start running again. They could have gone to the appellate court, to the circuit court, and said, we'd like relief in order to reimpose the fines. That's at least a 15-day process. And it's not difficult to do. I'm sure you gentlemen are confronted with that sort of thing all the time, where somebody wants, for example, a higher bond or a lower bond pending an appeal where there's a stay in place. They had all kinds of opportunities to seek relief, to reimpose the fines going forward. It's the reimposition of the fines retroactively that really is offensive in this case. And so if I thought the county was willing to work something on that, I'd be more than happy to do so, but I don't believe they are, which is why we're here.
Thank you, Mr. Hodges.
Thank you very much.
To exit our virtual courtroom, you need to click the leave button in the lower right-hand corner of your Zoom screen, and then you'll be gone. I, for one, could use a little 10-minute break, and so the court will be in recess for 10.